Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com.
Hi, everyone. Thank you for joining this episode of the podcast. This is a really important one for practitioners to follow. I think one of the most important because we're going to go through in detail the Department of State AILA Liaison Committee meeting from March 5th, 2020. Obviously, right now it's late June, but there's so many important points here that we need to go over that I thought I'd bring the best person to talk about this, a fellow colleague and immigration attorney, Mahsa, Khanbabai, who is on the Liaison Committee, just recently became a member of the Board of Governors. Is that correct?
Yes, that's right. I was fortunate enough to get elected to the BOG, so I'm really happy about that.
Awesome. So thank you, Mahsa, for coming. So we're going to talk about 2 points that are not on the Liaison Committee notes, but then we'll get to that. If you haven't, go to AILA's site. They have the DOS AILA Liaison Committee. It's for March 5th. This is supposed to come up on the Department of State's website as well, so it's accessible for everybody. The last I checked last week, it's still not up there yet. Who knows what's going on in DOS. But Mahsa, last night, right now it's June 23rd. Last night we got the non-immigrant visa waiver ban. Could you talk about your thoughts and impressions? You don't have to go in detail on it, but some things you thought.
Yeah, I mean, I think definitely we had heard about this coming, and so we're not surprised. The president is looking to distract from all of his failures, and we've seen him scapegoating immigration and immigrants for years now. So I think the highlights or the lowlights, as it is, of the new travel ban are that it affects people who are outside of the United States who do not have valid visas in their passports or valid travel documents. And so it's important that really be clear, because people who are in the United States as of June 24th will not be affected. Canadians will be exempt because they don't require visas. So there are lots of loopholes. It's a very sloppily written document. But thankfully, I think there are a lot of loopholes that will help individuals still be able to get a visa, even if they don't have one now, especially if they're in the United States.
It also doesn't include e-visa. So if you have an E2, that's still possible. And for Canadians, that's good, because Canadians, I think for E's and K's, they have to go to the embassy. This doesn't apply to either of them. Now, it is an extension of, not only is it a non-immigrant visa waiver ban, but it's an extension of the previous immigrant visa ban. And so both of them are going potentially until end of the year, if not longer, maybe shorter if they change their mind. The K-1 visa is this confusing muddle in between. A colleague of ours was communicating with one embassy, and they said we consider the K-1 an immigrant visa, so it's subject to the original immigrant visa travel ban. But interestingly, I was for preparing for this talk right now, I was reviewing the DOS AILA Liaison meetings. They specifically say here the K-1s are non-immigrant visas. So, the left hand doesn't know what the right hand is doing, but at least this may be some talking point you could use. I mean, this isn't regulation here we're talking about, but to show that, Department of State, like the entity, considers it a non-immigrant visa, the embassy should, follow up LegalNet or something like that to clarify that issue. And we'll get to that a little bit when we talk about it. We talk most of it here, but the K-1 is such a annoying thing that's in between it. It's not clear. And because embassies have been shut down, we don't have case examples of how it's actually happening.
Yeah, exactly. I mean, so definitely you should try to make whatever arguments you can about why your case should be exempt if you're a fiance and that it's a non-immigrant visa. Try to point to anything from the State Department regulations or policy memos that talk about it being a non-immigrant visa. So there's definitely things that you should try to do. Don't just sit back and take it.
Yeah. Now, there's a second thing that you had sent out. Again, it's not the liaison meeting notes, but about DS-160s and DS-260s. So as everyone knows, they added this question where they ask about social media, and they have a drop-down list of specific ones they want to know. But they added the second question then that says, do you want to offer any other social media information? And why give that information? Arrow marks no. Why create hassle and more time, whatever? Well, as it turns out, on the final draft, once you finalize that DS-260, for example, they changed that question where they said, it's kind of like a willing, a voluntary admission of information. They change it up and say, like, do you have other like information? I can't remember the wording exactly, but they make it sound like you're saying no to a specific request, and which could later on, potentially be considered misrepresentation. So I've gotten to practice of just including all the other social media info to avoid that trap, because it looks like a trap. But these are the kind of things that we deal with, and it's like, it's so crazy that it exists like this, but that's what it is.
Yeah, I mean, whether or not it's a trap or it's just very sloppy written documents, I think there's arguments for both with this administration. It's very, very important, as you say, to be careful to look back after, once you fill it out, and see how the questions really show up. Because when it's a drop-down menu, it might say one thing, but then the final version says another thing. So it would be best to just disclose all of your social media handles and accounts so that you won't be held to have committed fraud or misrepresentation. Because we know with this administration, they will look for any excuse.
Yeah. So with all that good news, let's get started. So, you know what, you want to go with the first thing that caught your eye, or the first note you want to talk about, the Liaison meeting notes that were interesting?
Yeah, so I mean, definitely, I think one thing that we've been seeing, which is concerning, is that the visa bulletin is being issued much later every month. It used to be issued much earlier in the month, around the 11th or 12th. Slowly, we started seeing it around the 15th and then 17th. And then there were, I think, maybe 1 or 2 months where it was issued around the 22nd or 23rd. And that makes it obviously very difficult for people to plan if they want to quickly file before their priority date is affected and they're no longer eligible. So, Charlie, who is in the visa office, in the State Department office, who handles this visa bulletin, is really an incredible professional, wants to do his job appropriately, but does have to respond and report to DHS officials. And so we think that's really where the holdup is. CIS, or within DHS, they've asked for an extra layer of review, and that's where the delay has come in. So it's not surprising with this administration.
Yeah, that checking with Charlie is so helpful that he does. It's so helpful. I'm surprised it still exists. I have to jinx it by even saying that. It's not even like private information, but it's just some helpful guidance to help try to figure out what's going on in this mess. This year, I think there's going to be 20 or 25,000 employment-based immigrant visas that are not going to be issued because of the travel bans. And so there's already such a delay for these poor people in China and India that are waiting. It's just more delays for them.
Yeah, so what we're seeing and what Charlie's reported, and you can read about it in the visa bulletin update that the State Department Liaison Committee puts out every month, is that all of those unused numbers from this year from the family-based categories, because obviously people can't go to the embassies and have their interviews, but also because of the immigrant visa ban, all of those numbers will carry over to next year's numbers for employment-based categories. So we expect to see significant movement forward in the priority dates, so that those numbers won't be lost, which is the good news.
Oh, interesting. I didn't know it worked out. I thought once the year ends, the fiscal year ends, they're disappear. I don't realize that there's a carryover.
Yeah, and there's a whole process and procedure about which categories get them first and second and third. It's pretty fascinating.
Wow, that's good to know. All right, so how have you been dealing with SEAC? As you know, it's been horrible.
Yeah, the system, I mean, just the capacity, the technical capacity behind the system is really lacking. And so there are, constant problems. And the State Department is aware of this. They're trying to work on it, they say, but it just takes time. And unfortunately, it's a matter of just really trying the different browsers, trying to save literally, maybe every other question that you fill in with the hopes that you don't lose data.
Yeah. And so when it comes to filling data, I haven't had that timeout problem in a while. It's probably because like when I'm going through residential history, every time I put one in, I save it and then I go back. So it unnecessary delays. But uploading documents has been a problem recently for me. It just like goes into an error page. And then I haven't had this issue, but people are talking about fee payment issues still existing where it doesn't work. And
Yeah.
they said they're stopping NBC's acceptance of mail. So I'm not sure if you could even mail a check-in like you used to as a backup.
Yeah, so I mean, I think those things change literally week by week, depending on what's happening at the location. So whether it's the NBC or the Vermont Service Center or things like that, some of these service centers have had, potential outbreaks of COVID and they were shut down maybe for a day or two. But mail should still be delivered. And so, but what you want to do is track the mail and make sure it actually gets delivered, because we have heard of instances where UPS or FedEx wasn't able to deliver something because someone was not there to sign, took it back to the facility to then later re-deliver, and sometimes lost track of the document or of the mailing. So do follow up. Now, one other little nifty tip that is in one of our Q&As or our practice tips from the State Department Liaison Committee is you can call the National Visa Center. They're open until midnight Eastern time. So I've actually called them sometimes at 10 p.m. Eastern time, 11 p.m. Eastern time, gotten someone on the phone within a matter of minutes who was incredibly helpful and was able to look to see what's happening on my case. But yeah, there's still lots of problems with uploading documents, as you said, shadows and things like that. So you really want to try to follow those tips in the communication with the NBC that we put out on how to address some of those persistent problems.
That was the issues with the electronics, but there's some issues with the manual aspect of it as well. I mean, electronics, the size of the uploads, they said they're going to increase it to 4 megabytes instead of 2, which will be like a godsend. I mean, I deal with Iranian marriages where their marriage certificate is like 20 pages. And no matter how low resolution scan I do, it just doesn't fit properly in there. I have to like figure out tricks to do it. But the manual aspect is we upload documents for NBC review once submitted, and we get errors in there. Like, first of all, the error is when they respond to us, that comment page, or it doesn't even open up, half an hour to open up. But that's it. I mean, you can't even practice with something like that. You just got to kind of guess at what they said. But also, when you do finally open up, you see like the things they're asking for are not even correct, or they're asking for like things that don't make any sense. So that pops up a lot as well.
Yeah, it's a persistent problem, and what happens is they're behind in their communication by 6 to 8 weeks. So even when you do submit something, it takes 6 to 8 weeks to find out. When you hear that they've rejected something, you don't even have clear reasons why, and then you need to try to guess, re-upload the document, and then hope that 6 to 8 weeks later you'll find out more. So please, though, do submit your reports to the State Department Liaison Committee. We have a link on our website for AILA, and we want to hear about these trends so that we can continue to raise these issues with the State Department so that they know that it hasn't been fixed yet.
Mm-hmm. And so one of the other issues is because of COVID-19, primarily the NBC's communication has gotten worse. And, it hasn't. One is you can't email them directly. Lawyers can, as they used to. Although when they respond, I think they use that lawyer email. But they've said there's increases in process. What is the situation? They have this thing that they broke down because COVID-19, only emergencies only. But I found that not to be really the case consistently.
Yeah, I mean, there's still processing cases. I think that there are some delays because some employees are working remotely. Maybe they're rotating in. We haven't heard from them recently regarding what their work situation is, but there are definitely delays. I'm not sure if you want to clarify a little bit.
Yeah, I probably should clarify. I didn't ask that well, but it's just it's specifically Ask NBC. So when you're communicating directly through their webpage, which is how they expect you to ask them, they said there's going to be delays. They're only dealing with emergency kind of cases. So it's like they may not answer you or it'll take weeks or months. But I found like I'll ask general kind of questions and they'll respond within a few days sometimes. Where I'm like, wait, I thought you guys are understaffed and you can't get to this. So I don't want to thank you for responding quickly, but the inconsistency is kind of weird. They're saying, don't waste our time right now because we want emergencies or else it's going to delay things, but there's not much of a delay when I do ask him, even kind of basic kind of stuff through the Ask NBC website.
I see. Yeah. So, I mean, definitely, I think they are trying to deal with the emergency cases first, but I'm guessing things have slowed down for them. And so reaching out is still a good idea, and ask your question. Maybe you'll be lucky like you and get an answer sooner, and sometimes it might take longer.
Yeah, I just did a change of embassy request, the embassy from London to Montreal, and that was done like within 48 hours. I was really surprised. I did a notification that we're adjusting status instead of doing constant processing. That I responded within a week, confirming that's being done. So I was like, oh,
And have
these
you
are
been doing it through their website, John? Are you
yeah,
going into that drop-down menu and filling it in?
exactly, yeah. The only issue is sometimes they'll ask for random things. Like when I did the transfer from London to Montreal in the past, I just gave the case number and that's that. And I sent them proof of the lease agreements and the visa that they're in Canada temporarily or on a work visa. But they're like, we need the phone number and the address as well, his local phone number and address. So I'm like, I haven't had to use the local phone number in the past, but now they're asking for that. So it's like every time the procedures kind of change, but their response was quick. Once I got that, I sent it to them. Their response was quick, and it was transferred. So now it's a Montreal case. So I was delighted to see how fast that worked.
Yeah, I had a case like that too, actually, but I'm still waiting to hear back from them. So I should follow up.
Oh man, that's it. So the consistency is just not there, and like a lot of immigration, it's depending on which officer, which agent is dealing with your case. Like this is USCIS. I called to make an expedite request. We put it in. A week goes by. I haven't heard anything yet. So I call them back because within 5 days they're supposed to email me or let me know what they want. And the person said, you have to wait 30 days. There's nothing in the system about your expedite. I'm like, that's weird. So I hung up, called back. Another officer said, oh, we emailed you the request already. And it turns out the email address was incorrect, so it didn't come to me properly. And I'm like, the other officer didn't even bother looking, or what was going on there? So I knew the procedure, so I knew they were wrong, so I called again. But imagine if you're a civilian doing this kind of stuff. They dangle you and you don't know what's happening.
Yeah, no, that's true. I mean, it's luck of the draw in terms of the training that these individuals get, and how then willing they are to look into your case. Like I said, that's why I've had luck in just calling them at 11 p.m. That person is not very busy,
Yeah.
and they're willing to look at things very carefully and talk to you.
Yeah, and they see the phone call. They've been surprisingly helpful in the past. They're very delightful and helpful. I've had good interactions with them, so I'm really surprised.
Yes.
USCIS has gotten better. They keep changing the call tree, and so it's all over the place. But since they're probably less busy than they used to, because they kind of like try to shut everyone out from contacting them, the officers are probably more friendly. Who knows? But moving on to there's one issue that really frustrates me, and the response that DOS gave to it really kind of infuriated me. For years, when I contact embassies through the US Visa Info site or whatever they have, like I'll send something to the mission in India and it'll come out where I get a response from Russia that says it's wrong. Or I contact Mexico and Costa Rica responds. There's some weird stuff like that. And then here, this issue was here, and the DOS response was, we were not aware of that. Thank you for bringing that to our attention. I've emailed them dozens of times, not dozens of times, I exaggerate, probably 6 or 7 times. And so they for sure know this issue exists. And I've actually seen it come up in other liaison communication with them. So it's like, I don't know. What are your thoughts? It's just...
I mean, sadly, I think there's a lot of empty positions within the State Department in terms of career officials who help make sure that systems are working well. And so, part of it is that. Part of it is not enough staffing on the ground level. Part of it is, this culture that's been created by this administration. So I actually really try to make the job of that person I'm interacting with as easy as possible. I give them a simple of breakdown and concise of an explanation of what the issue is, what's the thing I'm looking for, to make their job easy, because they're really having a difficult time. But yeah, they should be aware of that issue. We've brought it up with them as a State Department Liaison Committee, and please, just everybody, when you do run into these really strange things, report it. There's a mechanism within AILA to report all different kinds of trends. You could do it specifically to the agency, so for example, the State Department or CIS or CBP, and you could just do a general trend report. Because one interesting thing that I've seen over the last few months and reported it to AILA. And they responded that they've heard of this as well from a couple of other people, is that they're making mistakes related to foreign documents. So in particular, I've noticed this for Iranians, where they've claimed that X birth certificate issued by, X ministry is not the correct one. And they actually denied my I-130 petition, saying you didn't submit the correct birth certificate from the appropriate agency. We actually tried to have them reconsider based on government error. They refused to look at it. So then we actually went to the ombudsman's office and provided everything to them to show that this was a mistake. We submitted the appropriate agency or ministry's birth certificate. And finally, the case got reopened, and now it's at the National Visa Center. But several of my colleagues reported similar problems in that either CIS or actually, I think they've all been CIS, has denied I-130 petitions incorrectly based on a false report that it's not the appropriate ministry that issued the birth certificate or the marriage certificate.
Yeah, in the last 6 months, speaking of pandemics, it seems like a pandemic CIS where they're incorrectly judging documents. I got birth certificates that were plainly right, and they're just calling it out. And so I print out the visa reciprocity chart and I highlight it. I'm like, look, just look at it like this. This is that easy. Particular birth certificates, but other kind of certificates as well. That is consistent. It's very frustrating because you get notification. And you open that package as an RFE, you're like, what the world? Why am I getting an RFE? This is an I-130. I got an RFE right here for an I-130 where it's a marriage case where they're asking about children's birth certificates, divorces, when they're nowhere in the I-130 that we said they were ever married before. So that is just par for the course this year. And you wonder why they're going bankrupt. They're spending all this extra time and money on postage and responses and that are frivolous. That's going to happen. You're going to lose a lot of money. Just no way around.
I mean, the inefficiencies and inconsistencies and really poor service is what's led to them going bankrupt. Yeah, they become a public charge.
Yeah. Oh, man. And another thing that popped up, so I don't deal with London. I haven't had this issue, but apparently London is asking people to send a medical summary when they're coming in with them or something like that. And DOS said, we checked the post, there's no new medical exam requirements. And then I went to the website for London, and it specifically said on their checklist that you need to do this. So London has it on their website that you need this medical summary, but DOS here is saying it's not needed, and they check with the embassy it's not needed. But their website from like a week ago or 2 weeks ago did include this thing that they're claiming is not there. So, just go by what the website says to avoid delays, even if it's wrong. At the end of the day, we want to get the visa faster, so that's the main thing.
Yeah, I can't recall if London is one of the posts now. I believe it is, where the electronic, the medical records, the medical exam is submitted electronically to the post. Many embassies have started to do that now, and I think London is one of them where they don't give you the envelope anymore.
And Brazil has, I've seen. London, I haven't seen. But on a note, I got contacted from a guy because I do a live program where I do Q&A with the public. And this gentleman said he requested an expedite immigrant visa interview in London, and it was approved. This is a week ago. And they did the interview, issued the immigrant visa, and the spouse is here. So London is seeing immigrant. I mean, London is seeing people. Maybe it's an expedite emergency kind of case, but they are doing immigrant visa issuance in that embassy.
Oh, that's great. Did he say what his emergency was? Like, what was the urgent
He
reason?
didn't say what it was. Now, just a date appeal. Today's June 23rd, 4th, 3rd, or is it June 23rd? So it was mid-June. He didn't say what it was, but he did say he tried 5 times, made 5 requests until the 5th time was approved, which I was kind of weird. I kept doing it, but it works. Sometimes you'll think just I guess don't give up. That's a thing about some of this stuff.
If it's a true emergency, you won't give up, right?
Yeah.
And so I know different posts have been handling the emergency appointment requests differently. Some of them are much more friendly and willing to take cases, and others less so. So, for example, I had an individual in Australia who was able to secure an emergency appointment. And I had a physician who was able to secure them at Mexico City. So there are a lot of posts that are, especially depending on the type of work that you do, are very willing to take emergency appointments. I hadn't heard about that immigrant visa one, so that's good to know about their success.
Now, moving on, there's one here note, and I don't deal with I don't really deal with Philippines too much or Schedule A EB3 nurses, but apparently the embassy is questioning if there's a liquidated damages clause and denying cases for that. And DOS is saying, we are aware of this concern raised by the industry on this issue, and they are working with the post to ensure that these visas are adjudicated consistently. So just be mindful of that if you are dealing with that kind of case.
Mm-hmm. Yeah, sometimes they institute their own policies, which are incorrect, and then we're able to, as a State Department liaison committee, reach out to them to discuss it and see if they can try to fix it with the embassy. So definitely do report your cases to us, and don't just follow with what the embassy says. Don't just assume what they're saying is correct. Definitely look into it, do your research, and explain to the embassy why they're wrong in a very concise, clear, easy to read manner. Because again, you really want to make their job as easy as possible. You don't want them to read a 5-page memo when you could make it really concise and nice in 2 pages.
You know, I was interviewing Christopher Richardson, former consul officers, and 2 points he said is the U.S. doesn't want to read papers, or maybe 3 points. So don't send a lot of paperwork. Secondly, be polite because they could not care. They have consular non-reviewability. It's not like USCIS where you can kind of like get hardcore at them. And third, you know, the managers change every 2 years. So every 2 years, you might have a post that's the best post, and all of a sudden everything changes and they're not handling things like they used to. That's because they just have a new leader there. There's always changes that happen with these things.
Yeah, I mean, I think we've seen that with all of our Iranian cases, right? Remember, Abu Dhabi and Yerevan used to be terrible.
Yeah.
And now they've suddenly become really much better to work with.
Yeah. I'm surprised, delightfully surprised sometimes. Like, wait, that was easier than usual. And then Turkey sometimes has ups and downs, and like so I just never know. And so people always ask which embassy's better. I'm like, by the time we get to your I-130 done and your National Visa Center stuff starts, who knows who's leading, who's not, what immigrant visa bans are there. So with timelines, the main question, clients like asking how long things take. Like with COVID-19 and travel bans and Trump and budget cuts, like it's like maybe 1 year, maybe 3 years. And how good is that estimate? And they get really frustrated with that because that's like the one question, that and the price that they want to know quickly. I'm like, they might double or triple the work in 2 years. I can't tell you how much National Visa Centers work. So I even bifurcated my contract many years ago where when we start National Visa Center, we'll negotiate, or not negotiate, but I'll tell you what the price is then. But right now, I have no idea what's going to be happening. You might not be able to do it 2 years from now. We just have to wait.
Right.
It's happening in Iranian cases right now.
Yeah, I mean, with all of the different travel bans, it's really hard to know. And I think that's really a wise thing as a practitioner, that we need to, one, set our clients' expectations and let them know that based on the way the rules currently are, on current policy, this is what we expect. I always put it in writing so that they know, and I specify based on current travel bans, you're not likely to have a visa interview for, let's say, 6 months, a year, whatever it is. And then just keep in touch with them over time so that, one, we're helping them understand all of the barriers in place, that we're aware of these barriers, that they're out of our control, and that we're going to try our best when we get to that point that the case is finally completed at the National Visa Center and ready to be sent off to an embassy.
Exactly. And, going towards all those kind of issues, and the public charge pops up. So DOS has its own public charge, DS 5540. Do we need to submit it? Do we read the interview? What's going on?
Yeah, I mean, right now, I think everything is on hold. So it'll be interesting to see how the consular posts resume. Once they resume their services, how they're going to want this. But generally, it's a very simple 1-page form. And I've been having my clients, or I had my clients take it with them to the interview. And, they've asked a few questions related to the health insurance and things like that, but it has not been an issue for any of my clients when they were still conducting interviews. I'm curious, did you ever have any problems with the form?
I didn't have to submit the DS 5540 public charge form in that little bit of time that we had to adjudicate that they were potentially accepting those with DOS. And so I haven't had to deal with it, but I'm not uploading it to SEAC. And here it says on the liaison meeting, there will be a transition period in which applicants will not be required to submit the form to be documentarily qualified. So I'm not sending it to SEAC. I'm going to have clients take it with them to the interview, and if it comes up, to give it. But that form could just open up additional questions I don't want to deal with. So thankfully, it's not as bad as the I-944, the USCIS. So it used to be we'd prefer clients adjust status, but in consular non-reviewability, we'd shy away from consular if you don't have to. But with DS-5540 being so much simpler than the I-944, that I kind of prefer people to do consular processing now. But it really just depends on the client. But it's yet to be seen what kind of disaster public charge is going to be because of COVID-19 shutting things down and canceling interviews.
Mm-hmm. Yeah, I'd love to hear from those of you that are watching this, what your experiences are. So feel free to send me an email or send a report to the State Department Liaison Committee, because we want to hear about your experiences and make sure that things are following the procedures and policies as Department of State has said they'll be carried out. So do keep in touch.
Now, the next point is I'm reading off, I'm going on a list of these, number 34 on the liaison meeting notes. And I can't remember what it was, so I'm just going to read it so people know, because that's really interesting here. It says, if a consular post determines that the information provided to satisfy the requirements of INA 212A4 is insufficient, what is A4? Let me see. 212A4, is that criminal is 2, INA 212. Sorry, this is a 23-page list. So let's see. A4 is public charge. Okay, that was part of the public charge. So if for public charge they think there's insufficient circumstances, then they suggest the applicant could overcome the deficiency with additional documents or information, but refuses the application under the public charge rule instead of 212G. Is there a protocol that can be utilized to ask for review of such determinations? And they respond, the Foreign Affairs Manual at 9FAM 302.8-2B5 provides guidance to consular officers on when to refuse under 212A4, the public charge statute, and when to refuse under 221G. LegalNet will review inquiries with this distinction in mind, particularly as it is relevant distinction for applicants with I-611A provisional waivers. Applicants may overcome a 212A4, the public charge, by submitting additional documents that would address the deficiency in the same way they overcome a 221G refusal for missing documents. So that's if you get some sort of hardcore denial of those, that there's LegalNet review. I mean, I've never been really able to get LegalNet to answer anything of mine other than saying this is fact-based or something, even when it was legal-based, but it's worth a shot.
Yeah, I mean, I think if once the embassies start having interviews and public charge is a factor that's really being considered and looked at, my guess is that the consular officer will issue, a 212A4 inquiry or request. They might even just do it under 221G, frankly, and ask for documents, because I believe that there will be a lot of people, especially if they're unrepresented, who will go to the consular interview unprepared. They won't have the documents that the officer will want, and the officer is then going to ask for that. What mechanism they'll actually use, how they'll label it, whether they're going to label it, as a 212A4 refusal, but issue a 221G so that they can bring in the documents. I think it remains to be seen.
Yeah. And along with that, what I'm telling clients to do is, take an English exam if they're coming from a non-English speaking country, a TOEFL exam to show they can speak, and also to get a degree equivalency. So if they got a college degree in some country, get that, bring it with you, just as additional ammo, because who knows how the public charge determination is going to happen and how subjective it's going to be. That's going to be a mess, how subjective it is.
That's an excellent point. I think that's the most important thing, actually, is that you talk to each individual client and find out what's their background, what's their education, their work experience, what kind of documents do they have, can they get to help support all of those different little factors that might make a really big difference in their case. And it is subjective. And so depending on what country you're from, what kind of post it is, what kind of experiences that officer has had, did they come from a high fraud post in the past? All of that is going to come into play. So one of the most important things is to prepare your clients for the interview and practice with them. And I think there are a lot of practitioners that don't realize how important prepping your client and practicing with them and going over the documents, making sure they actually have it, maybe even preparing everything for them and sending it to them that they can print out, and be able to explain what are all of these different things.
Yeah.
I think there's an art to that lawyering that we need to pay attention to when it comes to these subjective issues.
And, with the public charge, it really becomes an issue for parents of U.S. citizens, and prepping them can be very difficult many times, and having them be able to, answer these kind of questions. So that's I think the hardest kind of case that can be parents of U.S. citizens, because Trump couldn't get that out of the INA. So now I think the whole point of public charge was just for the parents of U.S. citizen cases to get those out. And so that's going to be yet to be seen, but we'll see how difficult those are going to be at the post and how difficult they're going to do.
Mm-hmm. True.
And so the next one, we talked about this one already, but it's whether K-1s or non-immigrant visas or not. Here it says if PP 945 proclamation, I can't remember which 9945, which one exactly it is, but if it makes effect, would provisions be applied to K-1 non-immigrant visas? And they say K-1 is a non-immigrant visa classification in accordance with the INA and for purposes of the proclamation, which only applies to immigrants. So PP 945, which one was that?
I think that's
945. Is that the immigrant visa? This is in March, so
I think that's the immigrant visa ban. The one that supposedly to protect American jobs.
The suspension of entry immigrants will be financial burden. This is the health insurance one. They possess financial resources and health insurance. So this is in accordance with that one. But I mean, they can't really pick and choose how they're going to do the K-1. Is it a non-immigrant visa or is it an immigrant visa? So I would really challenge that. If you have a K-1, I have K-1s that are pending, I-129Fs that are pending. I'm going to say this is not subject to either of the trial bans for immigrant or non-immigrant visas, because K-1 is a non-immigrant visa, so the immigrant won't apply to that. And the NIV one only applies to some H's, L's, and J's. So, argue with them. And the post, maybe use this. This is point number 37 on the March 3rd, 2020 AILA Liaison committee meeting. And the answers are in red right there. They say it's a non-immigrant visas. It's a visa. So you challenge them with their own words.
Yeah, definitely.
Okay. So next one is Presidential Proclamation 9645. The most recent out of funding hardship. I can't remember what is the non-immigrant.
That's the Muslim travel ban.
Oh, okay. You know what? My notes were on the writing for the previous one going over. I moved it down, so I thought I'm going to pass that. But on the next page, on 13, it says AILA members continue to report the applicants are administrative processing for a waiver, PP 9645, following the first consular interview. And then the answer is the visa office is aware that CAC sometimes reflects a description. Oh yeah, so this is just this happened. This is a while ago. All of a sudden, overnight, they start changing the descriptions of what admin processing is, and people were freaking out. I'm sure you got the phone calls too. Mm-hmm. It's just the games they play on this is amazing.
Yeah, I mean, and I think part of it is really to try to protect themselves from the lawsuits that are filed, the mandamus and APA suits, saying that you've taken too long to make a decision on my case. So now they're trying to couch it in terms of, well, we did refuse your case and therefore it's not open. And I know that we're waiting to see how that's going to affect a lot of cases. I actually recently had a case denied at post after filing the mandamus and APA.
Really?
But not for those reasons, actually. It was more the reasons related to Iranians who are studying in fields that the U.S. government feel would be potentially dangerous. And it was refused under the 306. I think it was refused under 306. I'd have to double check. And so, I think that there's been going to be a rash of those decisions.
So it's interesting. So I might hear my kid banging on the door in the background, but let's say they got it for the field of study? Because is that the one from January where if you're in certain like construction industry or something different?
No, this is
I
something
really get
different.
you for field study.
Yeah, I can pull it up and look at it. I don't have it handy with me right here, but it's basically the one stating that it's something that could potentially be a threat to the United States.
Yeah.
And so I've had a number of different, mostly Iranians, who were denied based on their field of study. Either it's like related to pollution or, some of the things that are kind of esoteric. Right? This one was related to agricultural research, but also included remote sensing. So it could be even vague little things within a field that seems so innocuous, and it doesn't have to be something like chemical engineering or petroleum or something like that.
Atomic something or physics. Well, that's such a nightmare. Yeah, I have clients who come to me nowadays. I ask them, "What'd you study if you're Iranian?" Because I would never imagine those things would have been a problem. I would have said, "Oh, you're good." So you just never know what's going to be a problem in these kind of cases. Oh, what a nightmare. There's some talk about that in this. We'll get to it in a sec too. But in one question was about Mission Mexico inconsistently adjudicating the management consultant aspect, and they recognized that and said yes, we have to do training on sometimes. So if you have management consultant issues because they're not judging it based on the actual criteria of the TN visa, look into that and maybe contact LegalNet or DOS about that.
Yeah, no, that's definitely a great point. And again, that all goes to reviewing the FAM, reviewing the regulations, reading it, understanding it, and then being able to make your argument to the post why you think they're making a mistake.
And the best way to argue it is looking at the FAM itself, because that's their Bible. They don't want to hear about the INA. They don't want to hear about, adjudicators field manual or policy USCI's kind of stuff. That just offends them if you send them something like that. The best is go straight to the FAM and say, hey, listen, this is what you go by. And what was really interesting is the next one about E2 visas. Do you have it in front of you if you want to talk about that? It's a very interesting quote that they did.
Mm-hmm. Yeah, I mean, so definitely there's been an ongoing issue related to the State Department and how it's interpreting, physical office space. And so the question is basically, State confirmed that the reference to having a physical business office was not meant to be read literally, and that the regulations take into account a flexible view of what would constitute an appropriate e-enterprise. And then the state indicated in the past that it would consider providing additional guidance to posts on this issue and asking, have you done that? The State Department response was that they intended to make appropriate amendments to 9 FAM 402.9 to address the need for physical office space to qualify for an e-visa. So I think that kind of leaves a lot of question. What does that mean? Are they actually requiring physical office space or not? But one would expect that they wouldn't require physical office space. Have you come across this issue yourself, Sean?
I'm too afraid. Even on L's, some people have said they've used virtual offices for L's. I'm too afraid to mess around. I force them. I say, if you need, go get some cheap place to hold you over. And then once you come here, then go in the ideal place you want to work, have your office be. But the physical requirement, just psychologically for an officer to know, hey, you have a physical space is important, and not a home, not something that's zoned for residential, because sometimes they'll come back and say, well, we looked it up and this is zoned for residential. How are you going to do office space there? Or give me an office lease. Your landlord's lease as resident. They'll come up with stuff. It's mostly in the L context, but I just wouldn't mess around. But it seems like they're saying here that it's not required. So, if a client pushes you, maybe, or it's there. I'm sure a lot of people will be excited to hear about this, but I have a hesitancy to take advantage of something like that until it's really written down. Even then, I want my clients to have like a old school business, brick and mortar, even though it doesn't make sense in today's economy, because that's the way they're used to and that's the way they envision it. These aren't necessarily business owners themselves or people who have businesses, so they think about the caricature of how a business could work, which is they have an office, you have employees, you go 9 to 5, and the closer we get to that example, the better it is.
Yeah. So I'm actually just looking to see if they've updated the FAM So I don't know if you had a chance to look at it
No, I've
before,
looked at this since. No.
but I'm curious to see if they've made that change because this was from March, right? Yeah. But also, I think, you touch upon an important point that we're seeing not only with CIS, but with the State Department and the Department of Labor is, the world has changed. Regardless of even, now the huge changes that have happened with COVID, but, the world was changing, technology was changing, how we conducted business, and the Department of Labor and Department of Homeland Security were not keeping up with that. And I think it's a reflection of them being behind in terms of the reality of how business is conducted now, and that they need to catch up much more quickly. And I think now COVID has made it imperative on them to really try to catch up. And so I think it's something that we're going to have to try to push as immigration attorneys, as a bar association, to get them to recognize those changes sooner rather than later.
Yeah, do the training too, because some officers won't go to training and those still do old stuff. But yeah, just pushing them and educating them is the way to go. And speaking of education, on bullet number 45, here it says AILA members report that the consular post in Guangzhou, China, is making all parents file I-601 waivers for human smuggling, which when the petitioner entered the U.S. illegally, regardless of parents' answer whether they assisted or encouraged illegal entry. The response was I-601 waivers do not apply for NIVs, so there's no question. So that's something that's popping up. So that's what an annoying thing.
And actually, it's not just in China. I had a few clients from Southeast Asia, from I think it was Pakistan and Bangladesh, over the last year, that have had the same issue. And so I think there was some sort of new training provided to consular officers saying, look, here's another reason you should try to deny a case. Yeah. Find out if anyone ever took their kid to the United States when they were young, and that child then ended up, young person ended up staying in the United States. That's now human smuggling. So it's a really terrible, I think, policy change that hasn't really been publicized much.
It's just they're really sitting down. Because I always wonder what Stephen Miller is doing all day at the White House. What does he get paid for? They have a group. They're sitting down thinking, and they probably have some immigration lawyers. How can we really find something that's like out there to pull it in? And it's so tricky. But they have so much power to do that too. So it makes it difficult to do anything about it.
Yeah.
Okay. Now, even a 601 waiver, I'm not sure. I don't do waivers, but I don't even know how smuggling waivers work. But they probably don't need a qualifying relative necessarily for those. But I don't want to talk. But I haven't filed those if I don't know.
Yeah, I don't do a whole lot of the 601 waivers myself, but I know depending on the category that you do need to have certain ties, and certain family members will count for waivers and some won't. So you have to be really careful about looking up your particular case and making sure you meet the requirements.
And speaking about being careful, next thing is number 48. And on Form DS-160, where it asks, have you been arrested or convicted of any offense or crime, even though subject of a pardon, blah, blah, blah? Should a person who is issued a speeding ticket or traffic citation in violation of state law respond yes or no to this question? And the response the U.S. had was, I guess, reasonable. It kind of sucks, but, if you want to read the response.
Yeah, so it depends on the facts and nature of the offense. In Virginia, for example, if a driver exceeds the posted speed limit by 20 miles per hour or more, or drives over 80 miles, Virginia considers this offense reckless driving, which is a Class 1 misdemeanor, and is a serious criminal offense. But other circumstances, speeding might not be a criminal offense. So yeah, it's all about paying attention to the details, talking to your clients, looking up that state statute to see how is it classified. And so it's not just simply filling out a form, as many people seem to think it is. So it's really, you have to be very careful.
And this comes in both adjustment of status, even naturalization, when they ask about citations and stuff. A lot of times we say, well, it's just a ticket. But I'm in the West Coast. It's just an infraction. But here, I didn't know about Virginia law was like that, where it could easily be a misdemeanor. So you got to have people get the tickets, get their DMV driving records, even if it's small stuff. And my clients, I started doing this when they changed the N400 to N400 and the I-485, where they add the word citation stuff. I'm like, we have to tell them everything. And they're like, no, it's just this. I'm like, no. Unless it's like a parking ticket, if you're sitting in the car and it's supposed to be moving and you got a ticket, we have to tell them so they don't come back for misrep later. And then once they bring me the info, we kind of dig in deep to see what the exact charge were. A lot of times it's just running a red light, running a stop sign. But this really highlights just speeding 20 miles per hour over the range or going over 80 could be a misdemeanor. So that's it. Just in general practice, you got to be careful of all the details of these kind of things.
Yeah. When a person's in the United States, I definitely err on the side of caution and list everything, especially like on an N400 or a 485. Because it's better to tell the immigration office about it and then have them be able to say, oh yeah, this is not a big deal, versus not listing something and then having it come back to bite you later. When someone is overseas, then I may not go into something like a minor speeding infraction if it's not a criminal offense, because it's just not as necessary. Yeah. We have much less control over consular adjudications.
And as I said here, it's okay if it's an infraction you need to go into, but you just got to look into see what it is exactly. So if it is a misdemeanor, you do have to get the report, which may be hard. Misdemeanors probably have it, but sometimes for this stuff, they don't keep records of it. I mean, there's serious misdemeanors in some places. After 10 years, they throw it away. So then you have to get extra certified documents to say that it's thrown away, which is such a, with digitizing records, I'm surprised that they throw away old records so willy-nilly a lot of these courthouses. But that becomes an issue when they want these records. Oof, okay, so the next one is something we talked about, deals with a lot, which is visa refusals, point number 50, for Iranian and Syrian military members or former. And what their answer to the first question is kind of annoying. Is there a procedure through which visa applicants refused under 212A3B have an opportunity to seek reconsideration of the decision? And their answer is applicant may reapply and seek new determination of eligibility. Do you think by reapply they mean a whole new petition?
It seems like they are saying that, yeah.
So if you got an F4 petition, wait another 20 years, or F3 adult child, wait another 10 or whatever years, it's kind of a non-answer. It's like, get lost kind of thing to say just file a new I-130. It's a mess.
I mean, I think this is again where the big picture is something to understand the context, right? The State Department or the U.S. administration made a conscious decision to label SEPA and
the IRGC is Islamic Revolutionary Guard Corps.
Yeah, a terrorist organization, and knew full well the implications that this would have. And that it would, bar thousands of individuals from being able to obtain immigrant and non-immigrant visas because they will now have considered to have provided material support to a terrorist organization. And so even though this designation didn't take place until, I can't remember the date, it was something in 2019, individuals who did their military service with IRGC or SEPA, back in the 90s, or early 2000s are still now going to fall into this trap. And so, the battle is, within the administration itself. And so significant changes will not happen on a big scale until this administration is removed and this designation, which is the first ever of designating a government arm, a terrorist organization. Until that is removed, that's done away with, this is going to be a significant problem for any Iranian that's done their military service. Now, is it possible that on a case-by-case basis, people can try to request reconsideration and explain the circumstances of their military service and maybe get the decision changed? Yes, that's possible. Is it also possible that maybe litigation could try to address this issue? Yes, but you have to be incredibly well prepared to be able to explain what that military service was and how it did not constitute the provision of material support to a terrorist organization to try to get your visa overturned. So as you said, this is going to be incredibly damaging for people who've been waiting, let's say 5, 10, 15 years to get a green card. It might be a little bit less painful for those who are seeking temporary visas like F1s or J1s or H1s. But yeah, this is really a nightmare of a colossal standing here. And so it's terrible.
I've had my clients who have this once, because in January, I think is when it happened, where I just was getting calls left and right for denials for this, for people who are former conscripts in that section of their military. And so I got gun shy in the couple of cases that came to me. I had this, I put them at embassy stage and have not been submitting the documents for interview. Because I'm like, I don't know, the interview might get denied. And I'm too afraid for you to go there, get denied, have to restart the process, and also have a denial based on this thing on your record, and have that follow you. So let's say they change the rules later, they'll still go back and see such a denial. They may not pay attention to what it was and just deny you again. So I've been gun shy about that. One thing I have been doing is, again, interviews have not been happening, so I haven't been getting calls about this. But in January, February, I would get at least two people a week who would contact me denials for this. And I would send them all to Jay Garrett. It's not Jay Garrett.
Yeah, Jay Garrison.
Garrison, yeah, in Seattle, Washington State, because he loves suing, especially on this kind of national security stuff. So he could accumulate the cases for it. But because it is national security stuff, easily the district court could just deny the case and not want to see it and say this is the discretion of the executive branch, which is that's a scary thing. You can sue, but it's like really easy for them to win on it and for the client to lose. So I've been on a holding pattern, and it's something for people that don't do Iranian cases or just doing one-off. Know that this is one of the major things you have to talk about, even at the initial consultation for the I-130 petition. This is something you have to prep, or if you have an I-130 pending, it's like F4 brother or sister case, go talk with them, actually look into what their military service was, and let them be prepared that there's going to be delays. Now, maybe they have a CISPA situation. You want to submit the case for, just to get the age in there. There's ways to do that too without getting to interview maybe even. But just this is a major issue that exists.
Yeah, it's very, very complex. And if someone is interested in litigation, definitely you need to go to someone who's an expert like Jay on national security issues, who has a litigation experience to handle that.
It's good that we have these kind of, and that's one thing at Immigration Lawyers Toolbox I've been trying to do is find these people that are really into that and just push them all there, and so they could get all the information and like yourself, like when you talk about DLS stuff, go to the AILA's page and share that information, just so people know where to go, and each of us could have our specialty to help guide on this, because this is such a complex situation we're dealing with. Just not even just these Iranian cases, just the whole immigration situation. It's really hard for people to get it all. Now I'm talking about this all day, interviewing people from all over the place, and I study this stuff, I teach this stuff, and I'm still like, every day it's like, wow, it seems like I don't know anything yet, and that's kind of daunting sometimes.
It is, yeah, no, that's true in that each of us have our areas where when you have gone through, let's say, 10, 20, 50 cases, you've developed an expertise and understand some of those nuances. And sometimes it's really critical to take care of it right at the beginning, as you said, because trying to fix a mistake later is sometimes impossible. And so you need to address it head on right from the beginning and not create a bad record so that if the case does go to a lawsuit, you have a better chance of success.
And another one of these executive orders that was against Iran that was interesting here. The president, after we almost went to World War III when we killed the Iranian general, had another proclamation where he said, if you're related to certain industries in Iran, and it was a really wide pronouncement. I don't know if it has the exact words here, but it's like one thing it said is, if you are an Iranian that dealt with the construction industry, then you're banned because that's construction is controlled by the IRGC, the Sepah, or the Revolutionary Guard Corps, and so that's bad. But it's such a catch-all term. What is construction? If you're a day laborer, is that construction? So that scared me, and I was asking people now, are they in that industry? I had one case that popped up where the guy was in that industry, but when the proclamation happened, he was in Canada visiting his wife, who was a U.S. citizen, because he couldn't get the visa here. And like I said, listen, you're not working in this issue right now because when the proclamation came out, you were in Canada and you were not working. If you go back to Iran, continue not working, because this liaison meeting says that the date of day, where did I save that part? It says, we refer you to the Department of Treasury, which is primarily responsible for such designations. And this is textile industry manufacturing. Only activities that occur on or after January 10th, 2020 would be subject to sanctions under Executive Order 13902. So I mean, that there's a date for that sanction. So if they didn't participate after that date, use this liaison committee meeting to say maybe they're in the construction industry in the 90s and the 2000s, but not today. And there's a starting date for this executive order according to the Department of State.
Yeah. I mean, I'm also curious about what they're talking about specifically related to the word sanctions. Are they being coy and talking about like actual monetary sanctions through the Treasury Department? Or, is this really going to be a bigger issue and they're going to use this to deny visas to an individual? So I think we still don't know.
Yeah.
After a lot of this happened is, COVID happened. And so we haven't been able to see how does this actually play out.
Yeah, we haven't seen the fruits of it. But one thing that the administration has been doing, it was making immigration policy through the Treasury Department through their sanctions. So they'll issue something like they had a thing against Iranian mining industry because the mining industry helps the armament industry in Iran. So like, if you're related to them, you can't get an immigrant visa or non-immigrant visa too. And that's like a one-liner there that it wasn't part of DHS or DOS, but the Department of Treasury, DOT has that. So it's like you gotta just another agency we have to, as immigration lawyers, follow that's completely detached from that, but that you have to know when you're dealing with certain countries. And obviously for Iran, for OFAC, Office of Foreign Asset Controls, you always have to worry about that, transferring money, E2, EB5, all that. But our job is Department of Labor, Department of Treasury, Department of Homeland Security, Department of State. There's probably some other ones in there I'm not even thinking about. But it's immigration lawyers are becoming generalists. You have to know everything: criminal law, family law, like treasury law, securities law. This is an extremely complex area of law to practice.
I agree.
Awesome. So we're nearing the end for those who stayed on. Let's see. Proposed changes to B1 regulations, number 54. This one says, let's see. This rule would set the scope and procedures for a pilot program, business pleasure, maintenance of department. Okay, so I think it's about posting bond and making sure you go back home. They're going to be instituting that. I think it's part of the public charge kind of stuff. But there's always been this bond language where you could post a bond and come here. They never instituted it, but that may be the case. Now, the medical treatment, and they've gotten stricter on birth tourism, but you can still do medical tourism, even if your pregnancy has issues and you need to come to U.S. I never applied for a medical visa, but people do that. It's interesting. And sometimes you got to tell clients, because clients will come on a B2 to do medical stuff. That could be misrepresentation later. So they should really have a B2 specific for medical treatment and get that before they come, so they don't come back later and say, well, you even if you paid for it, that could be a problem. And another thing I'm seeing is CBP doing expedited removal for people who, like, 20 years ago or 30 years ago, they came to the U.S., had a kid, and then they'll say, well, show us proof that you paid for the kid's hospital. And they're like, well, that was 20 years ago. I don't have that. We're like, well, you use government services probably, so we won't give you the benefit of doubt, or we're going to deny you entry or something. So things you would not expect ever are happening.
Yeah, that issue has come up at consular posts for years now, at least for the last 2 or 3 years, where we hear a lot of reports, especially in quote-unquote third world countries. For example, in the area where I live, there are a lot of immigrants from Haiti, from Cape Verde. They have family here, they come here, they have a child, then go back home. And later, when they're applying to renew their visa 5-10 years later, the consular officer starts asking them, oh, you have a U.S. citizen child, she was born there, how did you pay for it? And then tries to deny them. Back then, it was based on the fact that, oh, you're going to go to the United States and stay there, but also that you didn't pay to have your medical care. So I'm really fascinated, though, that you've heard of individuals who've been subject to expedited removal for that.
Yeah.
When was that?
In the last, like in a couple, not those months ago, but at least two people, like 3 or 4 months ago, contacted me where they said, well, they asked about, you have a U.S. citizen child. I think the children are younger. They have like 5 or 6 year old children. They're like, show us the medical paperwork that child was born here with, like, you paid for it. They didn't have that, so they got expedited removal. And now, like, I have cases where people have had their kids here, like on L1s. And I say, listen, go get your doctor's bills, save those, and keep it on your phone. So every time you travel, it doesn't look like you have proof that you paid them or you had health insurance and the like. because if they want to, because what happened is they saw that like, oh, they're like, well, you're traveling with a kid. Where's your kid? Let me see. And they see a kid has a passport born in the U.S. They're like, well, you were pregnant when you came. Was that the plan? There's a misrep there, even though they didn't enforce that in the past. And then they'll say, well, let me see. They get it on like the public charge kind of ground of you're not paying for your benefit. That's the ground they get it on. And a person on a random flight is not going to be carrying around medical documentation of paying for the child. It's like the last thing they'll think about. But they get it if they want to. With the way the immigration laws are, if the CBP wants or DOS wants to, they can always deny a case. It's like you can do whatever you want.
Yeah, but for CBP, and the reason I'm particularly fascinated by that is because I've been really tracking what CBP is doing with expedited removal and the increased use of it exponentially over the last few years. And they're using it in circumstances where they should not be. And particularly where they're saying that there is fraud or material misrepresentation, which is really one of the only two reasons that a person can be subject to expedited removal. So, those cases, I highly urge people to fight those for a number of reasons. But if they institute a fraud finding, then you are forever barred from ever getting a visa to come to the United States again. Expedited removal is one of the most harsh consequences that it can be imposed by a CBP officer, and it's not supposed to be used nonchalantly as they have been. So if you do come across that issue, any of you who see this or hear of this, please definitely look into potentially trying to fight that expedited removal order. Feel free to call me. I'd be happy to talk to you about it and my experiences with it, particularly for the Iranian students that I've dealt with, but for situations like this, because that sounds like an inappropriate use. And there are some reporters who are tracking this data related to the increased use of expedited removal, especially when it's done incorrectly, as it has been.
Now, the problem with expedited removal is the way they wrote the statute, there is no appeal of it or anything. It's a final order. But the first thing you want to do is maybe contact the port to have a supervisor review it, and then maybe file a lawsuit. The district court usually will not accept it, but in some cases they will if they find some issue with it. Recently was, I think, a district court, appeals court, or Supreme Court decision where they found an exception to the review of expedited removal in like cancellation removal kind of case or something like that. Or asylum or something like that. But it's really hard to challenge. But if you really find it frivolous, I mean, you can push the issue, get people involved. There's no official format for the INA doesn't give an appealable way, but they could always undo whatever they did. So
so I had success in one of my motions to reconsider the expedited removal. They didn't rescind the expedited removal order, but they actually did remove the fraud charges. So this individual won't now be forever barred from obtaining a U.S. visa, but also this could impact them in their ability to get a visa to another country. Because we've seen that, for example, with the Iranian students who've been subject to expedited removal, when they applied to get a student visa to go to Canada or somewhere in Europe, they were denied. And those countries specifically said, you were subject to expedited removal and had a fraud finding from the United States. So it's really critical to fight that.
Wow, that's horrible news. The information sharing between the Western countries is really strong. Australia even. And so these things have massive consequences, not just for the U.S. Now, if they take away the fraud finding as just expedited removal, is that like a 5 or 10 year ban or something like that?
It's a 5-year bar.
Well, I'll end on a slightly better note. So we were going through this big change in the visa reciprocity charge for the filing fees for visas with regards to the length of visa, if they're multiple or single entry. And DOS in March said we are complete with our review. So we were getting a bunch of updates every week, it seemed. And some of them were crazy, like Australia's E2, thousands of dollars, for L1, thousands of dollars. But that's ended for now. And so we won't be expecting any huge changes coming up in that area.
Yeah, I mean, some of those changes were really dramatic. And it was interesting to note that some of them really did correlate to what those other countries were charging. So, for example, Australia did have and does have exorbitant filing fees for Americans that are looking to get work visas to go to Australia. So I wasn't surprised when I learned that, the US was then trying to change its schedule. So some of it did seem to have a reasonable basis behind it.
Yeah. I just wish, I mean, it's so unnecessary to have these. So I was like, I wish the other side of them would be lenient, or at least we would say, whatever, you guys have your fees. But when you're bringing, it just goes like the travel ban that came with the L1s. So L1s many times are coming here to really bring knowledge and grow companies in the United States. It's a job creator visa. In my opinion, L1s create jobs because you're doing it to grow it. There are companies that abuse it, just like the H-1B. But all my clients are coming here because they want to invest in the United States, have a thing here, a branch here. So, and they're all hiring because L1, unless you have to have a staggered, like a system where you have employees and employees. It's the organizational chart is so important. So you can't do an L1 without hiring Americans. And so they don't understand this, and they make a big deal, difficult stuff about it. At most, they should be, if they want to push it, be nuanced. Maybe certain L1s that don't have, the requirement, do you have employees underneath them? Maybe function managers, be more strict on that. But this just catch-all to hit that is so bad. And J1s as well, I mean, the language in the J1, it said it applies to like people are coming as camp counselors or interns and trainees. So that's the part where it takes away from U.S. jobs. But I'm going to see how they actually take you. If scholars are coming or medical students are coming on J1s, does that get affected or not?
It shouldn't, no,
It
because
shouldn't.
it's a different category within
Yeah.
the J1.
I was thinking it shouldn't, but an officer might just see, oh, J1 is bad. It's like, no. There's types of J1s, So that's my worry is they're going to get caught up in the crossfire of this stuff.
Yeah, I mean, that could happen with some of the newer consular officers, depending on how much training they get, which is generally really short. But I haven't had any issues yet with like medical physicians, residents, things like that. But it remains to be seen how CBP is going to carry out the new presidential proclamation related to Canadians, for example, because they're visa exempt generally.
Yeah.
So I think we're going to learn a lot more in the coming days and weeks.
And really, it's just to teach clients on what's going on, because I've had clients be denied, airlines not allowed to board because of a travel ban for COVID-19 that didn't apply to them. So it's really, I tell my clients, get educated on it, have copies of the paperwork, go and explain to the officer, push them to call the regional carrier liaison program with CBP program where they educate these airline agents, because they're afraid, they don't know what to do, they don't have time to think about it. But you got to, the clients have to know to be able to defend themselves in this, to be able to explain things through.
I'm curious, how have you been advising some of your clients, John, if they've been in Iran and they want to try to get an exemption, right, or try to exempt out of the COVID ban, and so they need to go to a third country for 14 days. Have you had success in any particular countries?
The problem is even the wealthier clients who could afford to do that haven't been able to find a country that'll take them. Like I had one that was trying to go to Malaysia and he couldn't get it done. And then another one, a UAE, you can't go to the UAE as an Iranian. So like just go to Dubai or something, which a lot of Iranians do. Turkey is not accepting Iranians too. So all the typical places they can't go to, which is problematic. Maybe Armenia, I'm not sure. So they've been kind of stuck. And the problem is a lot of them with immigrant visas have their immigrant visa expired now, which means once the embassies open up, they have to do another interview. They're subject to the immigrant visa ban anyway. So that means they're not coming until 2021 now that I think about it. So I have some clients right now, I just got to inform them. They're going to freak out right now. And so because they were subject to travel ban years until administrative processing was over. As soon as they came over, this hit, it's going to be another year now before they come. And these are some of the young people that are holding off on starting college, holding off on starting a family, because if they get married, they're going to destroy the visa category. So they're in these relationships. The families don't understand why they're not getting married. They're pressuring them. And I'm like, listen, the laws are like this. Don't get married. It just really destroys people's personal lives.
Well, I've seen some clients have success in getting visas pretty easily to go to Mexico. So I think that's something that Iranians need to start looking at, that Mexico takes Iranians pretty well, and there's no ban if they spend 2 weeks there. So looking at some of those South American countries might be a way to go.
Yeah, good point. A lot of them just couldn't afford it. It was like 2 weeks at a hotel and stuff. I mean, nowadays Airbnb probably could find a good deal or something like that. But I've told them, just go stay outside for two years. But like I had a case that was a Bulgarian parents of U.S. citizen, and they were going to fly to the U.S., but the airline wouldn't board him. And they're like, oh, no, you're European. So I'm like, go to Turkey and then get one of those Turkish airline flights that come here. But another one of them, had to stop in Amsterdam. Once they had to stop there, they're like, oh, now you're in the Schengen zone, you're out. So you had to educate your clients. Even the flight you're coming here can't have a stop, even in transit in Europe. So, you know, once you get the immigrant visa approved, you're like, okay, my job is done. No, it's not done until they come here and get the green card. You need to educate them on each step of the way.
Yeah, I'm curious to see what the administration is going to do about that Schengen, you know, travel ban, because I have a feeling that there's going to be a lot of pressure on them to rescind that, and maybe, you know, in the coming weeks we'll see that, which would help with a lot of. I think
they're European partners, because right now the airlines, I mean, they're going 5% of the regular flights to Europe. Even business tourism is so important for the European Atlantic trade. So they got to be lifting that one up as the COVID numbers are dying down. If they are not, who knows what's going on with COVID, but yeah, I imagine that's one that's going to open up. It probably took a lot of pressure on Trump to even pass that one in the first place. It probably, especially forcibly adding England and Ireland to that. But I have a lot of English spouses that are stuck, or they want to go back or stuff like that. Come to think of it, I have a lot of, I don't usually handle London, but I have upcoming I-130s coming, green card holder spouses and stuff like that. And they're worried, or it's like, so.
Well, they might qualify for some of the exceptions, so it's a good thing to keep an eye out for.
Yeah, we'll see. And one note is, I mean, if you want to test out the exception, you're in that northwest part of Europe, you could always try pre-clearance in Ireland and have CBP take a review right there, so you don't have to bother flying all the way across the Atlantic, you know, suddenly getting stuck, if you get on a plane to even come here. But
that's the thing. I think they're having trouble just getting on the plane in the first place.
Yeah,
they try to cut it off right from the beginning. So
yeah, it's and everyone's handling it differently. Every CB post, port of entry is handling it differently. I've seen a lot of inconsistent information from different posts. So ports. So it's a fight. The immigration, every case is going to be something that's a slow burn, and you're fighting your way through it. There's no easy cases. There's no easy cases. People call you, just paperwork is the easy one, and that's not the case. It's not the case. Either from Germany or from Japan or Australia, it just doesn't work that way.
Agreed.
Well, Mahsa John, thank you so much for being on this line and all this time. I think it's going to be a great episode. I mean, I think it's mandatory that if you're a practitioner that does even a hint of console processing, you have to listen to this episode, because it's chock full of information that could, you know, save your case or make a big difference on your practice. Again, thank you so much. And congratulations again on getting on the Board of Governors.
Thank you very much. And I appreciate you having me on and always talking about some of the really most important issues that people don't always know about and maybe don't understand the nuances of. So thanks for drawing attention to it.
You got it. One last thing, if someone wanted to contact you, what's the best email address for them to reach you at?
Yeah, so it's my first name, Mahsa, M-A-H-S-A, at mk-immigration.com. I have a Facebook page and a website, which is basically the same, mk-immigration.com. And, you know, feel free to email. You can, you know, Google me, and I'm sure my contact information will come up.
Thank you, Mahsa. Have a great day. We'll talk soon.
You too, John. Take care. Bye-bye.
Bye-bye.